Hey, Current Kono here. This video comes from a live stream that occurred while I was on my secondary PC. As a result, some parts of it are a little scuffed. I promise I opened my eyes.
All right. So last month, Trump made a executive order called Prioritizing Military Excellence and Readiness. And the purpose of this order was to, quote unquote, remove gender ideology from the military. Because the United States military has a clear mission to protect the American people and our homeland as the world's most lethal and affecting fighting force with a warrior ethos. I guess like those warriors like in Sparta who were shirtless and put oil on each other. And we need to have a policy that service members are free of medical conditions or physical defects that may reasonably be expected to require excessive time lost from duty for necessary treatment or hospitalization. Consistent with the military's mission and long-standing DoD policy expressing a quote-unquote false gender identity, divergent from an individual's sex cannot satisfy the rigorous standards necessary for military service, requiring hormonal and surgical medical interventions. A man's assertion that he is a woman and his requirement that other honors his falsehood is not consistent with the humility and selflessness required of a service member. So this was an executive order that Trump had put into place back in January that would require, within 60 days of this order for the Secretary of Defense, Pete Hegseth now, who, as we all recall, decided to quit drinking to be our Secretary of Defense, which is an insane thing to say, to basically move forward and ban transgender individuals from serving in the military. So that is the situation that we got ourselves into. Earlier this month or late last month, that actual memorandum did come down, and transgender troops were banned from serving in our military. And there was a process that would go through for removing them from military service, which is frustrating. As a result of this ban, 3 different lawsuits were filed to try to get injunctions to stop this ban, all recognizing them as being incredibly unconstitutional for a multitude of reasons, violating Title VII, violating equal protection under the law. You can't just willy-nilly treat different groups of people differently. We have a constitution. You might have heard of it. So, one of these lawsuits, Nicholas Talbot v. United States, resulted in a 79-page long memorandum opinion by a judge who essentially brought what's called a preliminary injunction against this, which, kind of stops this from going into place. Didn't Trump stuff bone spurs for 30 seconds before and after his physical to see if he was going to be drafted to Vietnam? He did do live. And he doesn't remember, which knee had his bone spurs in. So, in Executive Order number 14183, President Donald Trump focuses on prioritizing military excellence and readiness. He claims service by transgender people is inconsistent with this mission because they lack the requisite warrior ethos to achieve military excellence. The judge recognized the fact that the president has the power to, indeed the obligation to ensure military readiness. Currently before the court is plaintiff's renewed application for preliminary injunction. Plaintiffs who are transgender claim that this executive order and the Hegseth policy, the military ban, treats them as today's fill-in-the-blank group that's being discriminated against. Seeking nothing more than to serve their country, they ask the court to enjoin the military ban. That means to, stop it from going put into place. They claim that the Hegseth policy was rushed, reached a preordained result, which it did. It contains no analysis and has no exemption in name only. That it invokes to target a vulnerable group in violation of Fifth Amendment due process. So, plaintiffs beg to differ. Together, they have provided over 130 years of military service. They have served in roles ranging from senior military science instructor to artillery platoon commander. They've deployed under 4 different presidents. One is currently deployed in an active combat zone. They have more than 80 condemnations together, despite the fact that they're now trying to be forced out by the president. Defendant rejoins that service records are inapposite. The court must ignore them and instead defer to the military's judgment. The court recognized it has to defer to this, but not blindly. The president issued this executive order within 7 days of taking office, and Secretary Hegseth issued the policy 30 days later. There is no evidence that they consulted with uniformed military leaders before doing so. They pronounced that transgender people are not honorable, truthful, or disciplined. So the Trump administration, Pete Hegseth, are saying that transgender people are not honorable, they don't have a warrior ethos, they can't serve in the U.S. military. And their source is they made it the fuck up. They don't have
Did you know you have rights?
Sources for this. It's insane. Thank you for the follow. It wasn't something that they had spent, months or years going through rigorous analysis to be able to determine, should transgender people serve in the military? Should they not serve in the military? Is it appropriate? Is it not? Trump said, Pete, my boy, please get that beer out of your hand and go ban all the trans troops. And he did it. He immediately did it, 30 days later. Trump doesn't have a warrior ethos either. Can he be deposed as leader of the American Armed Forces? Fuzzy, that's a great question. That's called the 25th Amendment. He should, but a lot of people on the right think he does have a warrior ethos, that he is a warrior chosen by God. It doesn't matter that they have such sparkling records, that they've, fought for our country for over a combined 100 years. That there's, God, my brain, I just got, you know that feeling when you're like on something and then you just get knocked off of it. I'm getting back on. I'm getting back on this horse. I'm eating this horse. So the court included some of its, discussions with counsel in the opinion. The court is saying that transgender people or people with gender dysphoria, their inherent identity is inconsistent with a commitment to an honorable, truthful, and disciplined lifestyle. Is that demeaning to them? I don't have a characterization for that, Your Honor. I agree with the court. If you say, a group of people is not honorable or truthful, that they are deceitful about their gender identity, that they're a man pretending to be a woman, that's demeaning. Okay, and if I'm asked you about all the other words in the military ban with respect to the characterization of transgender or people with gender dysphoria, you would have the same answer. Yes, Your Honor. There's nothing supporting these assertions in the studies, right? Defense counsel. That says some things. No, Your Honor, not that I know of. No study says anything close to these things, correct? Of being, not honorable, not truthful, undisciplined. Correct? Defense counsel, none that I know of, Your Honor. So, counsel's being coy. They're just being called out. It's great. An action memo claims that the policy was informed through consideration of 3 studies and cost data. Who considered the information, however, is anyone's guess. Defendants do not know. Maybe no one, because one study is 8 years old and the other 2 support the plaintiff's position that transgender troops should be in the military. Transgender troops have served openly since 2021. But defendants, the government has not analyzed their service. They made the decision to cut them out of the military without looking at the results over the last 3.5 years. That is unfortunate. Plaintiffs' server records alone are Exhibit A for the proposition that transgender persons can have the warrior ethos, physical and mental health, selflessness, honor, integrity, and discipline to ensure military excellence. The defendants agree, the government agreed, that they agreed that the plaintiffs are mentally and physically fit to serve, have served honorably, and have satisfied the rigorous standards demanded of them, but they are throwing them out anyway. Why discharge them? Why discharge these decorated soldiers? They don't have a good fucking answer for that. They just don't have a good goddamn answer. So, to obtain injunction, plaintiffs must establish a likelihood of success on the merits. And we'll go through the elements of what make up an injunction here very soon. The court's factual findings, the vast majority conceded by the government and all supported record, make it highly unlikely the military ban will survive judicial review, no matter what the level of scrutiny is. Rational basis or intermediate scrutiny here. Let me focus in on this for a moment. These are terms which talk about what level of thought the government would have to put into the military ban in order for it to be legal. And these are based off of the type of lawsuit it is, the type of person who's being discriminated against. If it's rational basis review, that means the government could, discriminate against this group of people if they have any rational basis for doing that. They have one study that says it's good. If they believe it'll genuinely improve military excellence and they have something to back that up. They don't even have that, according to this judge. Intermediate scrutiny. We don't even have to go into that, but that basically means the government would have to show, a substantially good reason to ban transgender people. And they clearly don't have that. Plaintiffs must also show irreparable harm and that the balance of equities favor an injunction. On the former, plaintiffs face a violation of their constitutional rights. Having your constitutional rights violated, getting kicked out of your job, is irreparable harm. Indeed, the cruel irony is that thousands of transgender service people have sacrificed, some risking their lives, to ensure those, for others, the very equal protection rights the military ban seeks to deny them. On the latter, defendants have not shown they'll be burdened by continuing the status quo, keeping transgender folks in the military, pending this litigation. And avoiding constitutional violations is always in the public interest. Making sure people don't have their rights violated against them is always a good thing. The reason is hate, but you can't say that in court, I assume. So that's what's called an illegitimate purpose, Janussi. If the government just comes out and says, we're banning trans people because we hate them, that's not a rational basis. There's nothing rational or logical in basis or in fact. That doesn't mean that's not the reason, and we're going to get into that. If the reason appears on the surface to be hate, or if you dig into it, if there's hate that's underneath the surface, that's basically trying to figure out why the ban was put into place. So we're going to skip through some of the facts because we're just going to get to the actual legal analysis here. And basically, this is 30 some on pages about how there are no studies that support this. The studies the government put forth actually show that transgender folks should continue serving in the military. So the traditional goal of the preliminary injunction is to preserve the status quo, which is the last uncontested status which preceded the pending controversy. So that means, the entire purpose of an injunction is just to keep shit the same. Don't let it change. Keep stuff where it is so that no one has their rights violated. To do that, you have to show it's likely to succeed on the merits. Here, the transgender military ban is unconstitutional upon a preliminary review. So the plaintiffs, they succeeded that. You have to show you're likely to suffer irreparable harm in the absence of preliminary relief. Losing your job, losing your constitutional rights, being discriminated against is irreparable harm. That the balance of equities tip in his favor. What that means is that looking broadly to what the military needs to act properly versus the rights of the transgender folks to not be discriminated against, to continue on with their lives. Which side needs this more? There's nothing showing that the military is actually going to be harmed by this. So the balance of equities tip in favor of, the trans folks. And then an injunction is in the public interest. What that means is you can't just have privately motivated reasons to get the government involved to stop something. You have to show that a large group of people, that people outside your own private interests, support this. And here it would be, the interests of other transgender military, servicemen and women, and other folks who want to actually serve as well. But there's basically, 3 different cases that are interesting here that I want to talk about. And the first one of those is the Singh case. So the Singh case was basically this case from a few years ago. In the Singh case, this was basically, a case in which a Muslim service member...
Editor Kono note. I meant to say Sikh here, not Muslim. I'm going to be talking about the Muslim ban here in a few moments, and I've mentally got them mixed up. So it's Sikh, not Muslim. Back to Stream Kono.
Wanted to, I believe, wear his traditional headdress and, not be able to be, kind of in tune with the grooming standards for the Marine Corps. And this case basically found that, while the government has to give deference to what the military wants to do, they still have to recognize the individual rights and liberties for individuals. And they found that in the Singh case, the military justifications came up very short. that the rights of the individual to their religious freedom overweighed the somewhat legitimate interests of the federal government. Something that's really bothered me about this injunction, though, I can tell you that someone who's still in the military, this is unjust. We can't afford to lose more soldiers since our recruiting is historically low and our retention is even worse. Gorilla Brown, are you telling me that at a time when like more Americans are obese than any time in history, where there's so many mental health disorders that are stopping our teenagers from being able to even join the military, that we shouldn't be, just willy-nilly getting rid of military service members? You think that's crazy? We shouldn't be getting rid of people who have Purple Hearts, who have served adequately for 20 plus years? That's crazy. That's crazy. We're the greatest military force in the world. We're just so great. It's just breaking me. One of the things that bothers me about this injunction is that it uses the Trump v. Hawaii case as well to legitimize it. So, if no one recalls what the Trump versus Hawaii case is, this is what was called the Muslim ban.
Did you know you have
7 or 8 years ago?
The Constitution says you do.
So the Muslim ban basically was a ban on 8 predominantly Muslim countries to prevent those folks from entering the nation. We knew why we were getting rid of those countries, because they were majority Muslim. This was proclamation number 9645. The proclamation implemented entry restrictions for foreign nationals from 8 countries whose systems for managing and sharing information about their nationals the president deemed inadequate. And plaintiffs in Trump v. Hawaii challenged it as a violation of the Establishment Clause, alleging it was motivated not by concerns pertaining to national security, but discrimination against Islam. They were unsuccessful. So the court, looks at the Muslim ban, which was upheld, and compares it to the military ban. And this is what, really bothers me, because here, you're right. I'm so sorry, Matt. You're absolutely right. The person in the Singh case was Sikh, not Muslim. Thank you for the correction, Matt. Because, Sikh folks have a traditional headdress that they wear. I'm so sorry for saying that they were Muslim. I had gotten that mentally mixed up with the Muslim ban, which was the next case, because I had prepared all this ahead of time. So I don't like this, because the court basically makes a roadmap to tell Trump how it could theoretically make a transgender military ban that might be upheld. So Trump v. Hawaii was called facially neutral. That means it wasn't banning Muslims, it was banning people from 8 Muslim countries. Who knows why they were banned? There were multiple working groups who worked on this. There were multiple iterations of the ban, which means, it went through multiple different ideas and thoughts. It had no derogatory characterizations about, people from this country being, animals or something. The alleged animus statements were outside the proclamation's text. It was just, Trump going on Twitter saying, it's a Muslim ban. These are bad people coming into our country. Where here, the transgender military ban has these dishonorable statements in its text. And there was, a review process, and there was, waivers in the Trump military ban that would allow certain individuals to come in after additional scrutiny. So I don't like how this is setting up basically a roadmap how Trump could, pass his ban. Because that's kind of what it's doing. So the real issue here is that this ban violates a case called Bostock v. Clayton County, which was a 2020 Supreme Court case which basically found that Title VII protections apply for transgender people. Title VII is part of the U.S. Civil Rights Act from the 60s that protects people on the basis of their sex, their religious affiliation, and a few other traits. So basically what the court found in Bostock was that if you are discriminating on someone on the basis of being transgender, you're discriminating them on the basis of sex. Because, for example, let's say you're discriminating against a transgender person who is a male wearing a dress, which is generally a female article of clothing. Well, you wouldn't be discriminating against a woman wearing a dress. And in the reverse, let's say you're discriminating against someone who is, biologically a woman, who is wearing, like, a suit, who is wearing, like, male clothing. Well, you wouldn't be discriminating against a guy wearing a suit. No, you'd say, wow, Kono, you look really good in that suit. That's a really great tie. Is that a Trump tie? Why are you wearing a Trump tie? Oh, you're wearing a Trump tie because you don't want to have Trump go after your law firm? That makes sense. We talked about that story earlier. So that was the Bostock case, and that was actually a Supreme Court case decided by Trump's own judge, Neil M. Gorsuch, who made it, asserting it's impossible to discriminate against a person for being homosexual or transgender without discriminating against that individual based on sex. Because at the end of the day, you're saying that they're not doing an activity, that they're not dressing the right way because of their biological sex. So in that way, transgender discrimination is sex discrimination. And you have to have some damn good reasons to be the federal government and to discriminate people on the basis of sex. So here, the court agrees with the defendants that Bostock's holding is combined to Title VII, but its reasoning is not. The Supreme Court deduced it's impossible to discriminate against a transgender person without discriminating against that person based on their sex. So 3 circuits have applied that same logic in the Fifth Amendment context, for what's called like substantial due process rights. The Fourth Circuit found that discriminating on the basis of a gender dysphoria diagnosis is discriminating on the basis of gender identity and sex. In contrast, the Fifth Amendment addresses all manner of discrimination by person, applies different degrees of judicial scrutiny. So basically, looking at Bostock, here the court found that, we're discriminating on a person on the basis of sex. You're not allowed to do that. So for all these reasons, the transgender military ban had a preliminary injunction against it. It still might go into effect after the actual lawsuit's over. Shortly after this came down, U.S. issued guidance on transgender military ban seeks to lift court order. So shortly after this went down, the court, not the court, but rather Pete Hegseth and his group looked at this little chart right here and said, "Oh, Your Honor, I didn't know we just had to do all of these things and then our illegal transgender military ban would be perfectly okay. I guess we're just going to do these things and we're just going to make a second ban based off of gender dysphoria." So shortly after this came down, we have a new memorandum, which they're at least, not implementing while the preliminary injunction's in place. So instead of, talking about, folks who are transgender or who have a different gender ideology, it's talking about individuals who have a current diagnosis or history of or exhibit system consistent with gender dysphoria are no longer eligible for military service, will be through reviewing medical records. So they're making by focusing on gender dysphoria, they're trying to make it what's called a non-facially discriminatory ban. They're trying to say, this is just mental illness. This is gender dysphoria, which is part of, the psychological handbooks. And that's disturbing. They're basically just admitting that the original ban is likely unconstitutional, and they're just trying to pave over it and do the exact same thing. Gender dysphoria is a distress experience when a person's gender identity does not align with his or her birth sex. The memo states that the exclusion of people with symptoms of gender dysphoria applies only to those who have marked incongruence and clinically significant distress or impairment for at least 6 months. So now they're basically creating, this is non-facially motivated. We just want these people who have severe mental health disorders out of the military. So that's how they're planning on getting around this, by making a new memorandum and then asking the court, which they did on Friday, to lift the transgender military ban injunction based off this new guidance, which is here. This is the motion that they're bringing. And I have to note, this motion's 4 pages long. One of them's almost totally the signature page. One of them's just the cover page. This motion's 2 pages long. So, would this mean everyone with PTSD would have to be ejected too? No, PTSD is not mentioned directly. I would imagine, you wouldn't want folks who have severe PTSD to be in the military. But yeah, so that's how they're going about this. So in their motion, they state that the injunction is premised on the court's view that the Hegseth policy bans all transgender troops. That view is in turn based on interpretation of other things the following language of the DoD policy. Service members who have current diagnosis or history of or exhibit symptoms consistent with gender dysphoria are disqualified from military service. Defendants have explained, however, that the DoD policy, presumably barring individuals serving in the military, turns on gender dysphoria, a medical condition, and does not discriminate against trans-identifying persons as a class. Chat. If you had a fully transitioned transgender person, let's say someone who's had top surgery, bottom surgery, who's had all their hormones, and is like, I don't have any gender dysphoria, I'm in the right gender now. Do you think they would still be, discriminating against this person, saying that, oh, you had gender dysphoria at one point in the past, we're kicking you out. You have a future possibility of gender dysphoria. Type 1 if you think a fully transgender, I apologize for using it that way. I mean, a fully transitioned person who has no gender dysphoria, because they're totally cool now, totally all great, would be discriminated against. 111, yeah, they would absolutely keep discriminating against this goddamn person. It's all a... I was about to say some things. About to say some very, very mean things. In pertinent part, the new guidance confirms that the phrase exhibits symptoms consistent with gender dysphoria refers to the diagnostic criteria outlined in the DSM-5 and applies only to individuals who exhibit such symptoms as would be sufficient to constitute a diagnosis. Because the March 21st, 2025 guidance confirms the court has misconstrued the scope of the DoD policy, thinking we're getting rid of all trans people. We're just really getting rid of all those gender dysphoric people. Please dissolve the injunction. This isn't talking about the fact that, the people who have this condition, gender dysphoria, are going to be transgender and non-binary people. That this is the same exact group. This is like, honestly, in all honesty, this is like saying, no, we're not going to be discriminating against individuals who are black in the military. No. We're going to be discriminating against individuals who have a high level of melanin in their skin. Your Honor, you've misconstrued the scope of the policy. We're simply just concerned about the amount of melanin in the skin. That's what's happening. I have no idea if this motion is going to be successful. My guess is no. I think, it's still a level of animus in the underlying policy that just cannot be allowed. You can't just make a new policy and call it a day, or at least I hope that you can't.
Hey, I hope you enjoyed that video and learned something. Please don't forget to leave a like, and if you think you know more than me, leave a comment and I'll take a look. Don't forget to subscribe, and if you want to let the algorithm feed another legal video down your gullet, please click on your screen right now. Thank you.